This presentation is for the Communications 320 Media Law course, and we'll discuss the Snyder versus Phelps Supreme Court decision and its effect on the definition of matters of public concern. Snyder versus Phelps, the players. So the two litigants in this case are Albert Snyder and Fred Phelps. Albert Snyder is the father of Matthew Snyder, who was a Marine who fell in the line of duty and came home, sadly, just to be buried by his family. Fred Phelps is the leader of the Westboro Baptist Church who protested his burial. The events that led to the Supreme Court decision started out on a typical day in March of 2006. It was on this day that Matthew Snyder's family were to lay him to rest in his church graveyard in Westminster, Maryland. However, the Westboro Baptist Church was determined to spin this event to spread their homophobic message throughout the media. The protesters got what they wanted, and it was through this media attention that Albert, the father of the fallen Marine, first became aware of what was being said about his son's death by the Westboro Baptist Church members. This case first went before a jury in the District of Maryland Federal Court, where Snyder sued Phillips for intentional infliction of severe emotional distress for the horrific accusations that were made against his son and himself during the emotional period surrounding his son's burial. Initially, the jury in the federal case found in Snyder's favor and awarded him $10.9 million, but the judge in that case lowered that total to $5 million. The case was then remanded to the 8th Circuit Court of Appeals, where it was found that the speech in question was protected under the First Amendment. The judgment that was reversed by the appellate court was reversed because they felt the Westboro protesters' right to free speech in regards to matters of public concern outweighed the state tort claims of intentional infliction of emotional distress, intrusion upon seclusion, and civil conspiracy. So the question before the Supreme Court was approximately, were the Westboro Baptist Church members exercising their First Amendment right to free speech by openly discussing a matter of public concern when they picketed the burial of a U.S. Marine that had died while deployed to a war zone? When all the arguments had been heard and considered, the Supreme Court upheld the appellate court ruling. In his statement of opinion on behalf of the majority, Chief Justice Roberts acknowledged that there was a basis for making a claim for the intentional infliction of emotional stress, but Roberts further reasoned that the death and burial of a soldier that gave his life for his country in a foreign land was justification for that the event was a matter of public concern and filled the criteria of being political, social, or of other concern to the community. The single dissenting voice, Justice Samuel Alito, stated in his dissent that a commitment to free and open debates does not give license for one party to viciously assault another party, and he feels that is what occurred in this instance. Justice Alito recognizes that the Westboro Baptist Church has a right to express their religious and political views in a manner and using terms that are uninhibited, vehement, and caustic. He does not feel, however, that the church intentionally inflicting severe emotional distress on a grieving family constitutes the discussion of a matter of public concern, rather is more consistent with the personal attack. There was a concurring opinion that was posted by Justice Stephen J. Beyer, who wrote that there should be a caveat added to be considered for future discussion that if one party chooses to assault another party in a manner that makes the assault newsworthy to get their point across, this is not to be considered free speech and therefore should not receive the First Amendment protection. As surprising as this verdict is to me, it appears that it actually comes in a long history of precedents. In 1940, the Supreme Court set precedent that religious beliefs do not constitute hate speech. In Cantwell v. Connecticut, the state had attempted to silence Jehovah's Witnesses when their speech became derogatory towards the beliefs of Catholics. The Supreme Court at the time rendered a judgment that since no specific threats were made beyond being damned for worshiping incorrectly, that the speech of the Jehovah's Witnesses was protected under the First Amendment. A few decades later, in 1971, a man named Robert B. Cohen was arrested for wearing a t-shirt protesting the Vietnam that said, we'll just say, F the draft, stop the war. The Supreme Court determined that one man's vulgarity is another man's lyric, and vulgarity was now a protected means of emoting an expressive thought. Thank you for your time. I hope you enjoyed my presentation.